And if I had to be another person to stand up, if I think, after really going through this, and looking at the files and looking at the case, if I really feel that Karen Reed didn't do this and I have to be a voice that stands up and helps, I will.
We are expecting to learn more about the allegations against the girlfriend of a Boston police officer who was found unresponsive in the snow Saturday morning. I-Team sources say Karen Reed was in a relationship with John O'Keefe. She's facing charges including motor vehicle homicide and manslaughter.
We're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Now, just be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life.
Yeah.
I tried to save his life at 6 in the morning. I was covered in his blood. I was the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she admitted to it.
No, she didn't.
That's not true.
She asked a question. She asked a question, which is very different. She didn't admit to anything.
I'm going to tell you one thing. Karen Reed's not going to fold. Karen Reed's not going to give up. Defense team's not going to quit. The Free Karen Reed movement is going to continue. We will continue to raise funds for her. We will continue to do standouts across Massachusetts, across the nation, across the world to let everybody know what's going on here in the state of Massachusetts, the corruption. And we will continue to get the word out there. Believe me. Believe me. Good morning, everybody. Hopefully you can hear me. I just actually got a heads up that the hearing is delayed until 10:30. Hearing is delayed until 10:30. So I think what I'm going to do, just to eat up some time here, is find something to replay. I'm actually at home today. I'm not in the studio. I have I have the day off. My car is actually in the shop. Hopefully y'all can hear me. But I just got notice that the hearing is delayed until 10:30. So probably what I'm going to do is just find something to play in the interim so I can keep this feed open. So just bear with me here for a second. Maybe we'll go to the last. Oh gosh, it's going to get confusing. If I go to the last Karen Reed hearing, people are going to be like, what is going on? Okay, awesome. Everybody can hear me. Yeah, it's going to be a little bit of a delay. 10:30. LV Cops in the house said, can hardly hear me. Come on, man. I'm not in the proper, I don't have the proper equipment here. See if I can turn my microphone up a little bit. But yeah, we're on a delay. Let me see. Hearing is delayed until 10:30 a.m. Perfect. He's probably messing with me. Steve's probably messing with me. So we are on a delay. Hearing is delayed until 10:30. From what the expectation is today is that we're going to get all of the motions cleared and off the table. And I'm wondering, the motion that they put in the other day, Hank Brennan put in the other day about getting Karen Reed's, using Karen Reed's statements against her, the recent statements that she's made in documentaries and, to newspaper interviews she's given in articles. So I think they're going to clear some of that up today. I just actually made a really badass photo that I want to share with everybody here. Because every time I think of Karen, I just, for some reason, think of this movie. Let me just put my stamp on this here and I'll reveal it to everybody here in a second. This is pretty funny. But again, hearing is delayed until 10:30. If you're just jumping in the chat, again, I know everybody's out there probably watching all the law tubers, but what I try to do is I'll just run the feed and not pause it or anything like that. So everybody can kind of just hear what's going on because I like to sit and listen to what's going on here. So I'm going to share my screen here in a second. Let me do this. Excuse me. This is actually pretty cool. I kind of like this. Give me a second. I'm going to share my screen in a second. Again, if you're just popping into the chat, the hearing is delayed until 10:30. And I'm at home today. Cop tubers can't stream because our bosses aren't down with that. Geesh, Steve. Yeah. It's going to be different for me this year too. This trial in year. I won't be able to stream as much during the day because I have worky work, but we'll do recaps at night. And then tonight, if you all don't know, I have Todd McGee, retired Mass State Police Todd McGee, on with Martin Radner from the Brother Council. And that's going to be at 8 p.m. Eastern Standard Time tonight. All right, let me just download this, and then I want to share my share my screen. I just always this came out really well, and it actually came surprisingly a lot better than I thought was going to happen. So let's see. Actually really impressed the way that this came out. So we are on a delay. Sorry, I wasn't really prepared to come on air today and talk. I was just going to play the feed, but I got a heads up from an inside source that said the hearing was delayed. All right, let's have some fun. I'm going to share my screen here in a second. So I don't know, for some reason, I just always get this kind of badass feeling, about Karen, the fighting back. And actually, I can probably do it this way. Yeah, let's do this. So if y'all familiar with The Legend of Billie Jean, have you ever seen that movie? The Legend of Billie Jean. I think everybody has probably seen that movie at some point. Well, this morning I was messing around because I don't know, like the whole fair is fair and fighting back. I always get that vibe from Karen. So I did a little, I'll share this on my socials later. I reworked it, and we've got The Legend of Karen Reed. And I changed the title. When the Commonwealth of Massachusetts wants to fuck with you, and you're about to prove them wrong. And then on the bottom here, I don't know if you can see it. Oh, you can't. It says, instead of the original Pat Benatar song, Invincible, I changed it to features the Turtle Boy smash hit Bang Bang. So if you're an 80s kid like myself, you'll know that movie, and I'll post that up on Twitter and Facebook. It came out great. I was really impressed. I mean, it looks so close to the original poster. Give me 1 second. I got to take this phone call. That was a lot more than I thought. My car is actually in the garage today. It actually it's going to cost a lot more than I thought it was going to be. But anyway, I'll get this posted up on Facebook and Twitter. So if you all want to share this, I'll probably post it up on Instagram as well too. Again, we're in a delay this morning for the hearing. It's scheduled for 10:30. There is a delay, and I don't know. Now we wait. Now we wait. So about another 15 minutes here. Stephanie likes it. LV Cops checking in. They love it. Gal said she's seen the movie. I'm going to post this one up. See if I have any. Excuse me. Good morning. Good morning. Facebook checking in. Yeah, Helen Slater. That's who it was. Yeah, with Christian Slater. That's brother and sister, correct? Am I right about that, Teacup? They were related, correct? I'm sure everybody's familiar with that movie. Again, we're in a hearing. Gosh, I keep saying trial because we're so close to the trial. We're in a hearing delay. 10:30 will be the time the hearing is supposed to kick off. Excuse me. Good morning. Good morning. A lot of Facebook people checking in this morning. Not related. Oh, wow. Interesting. I would think they would be, right? Good morning, N. Thanks for checking in. Again, if you're just checking in, we are in a hearing delay. The hearing is supposed to start around 10:30 this morning. And I wasn't really scheduled to talk this morning, but I guess here we are, right? I'm working a little bit behind the scenes. So let's see. Put this back up. Clarissa checking in. Good morning. Yeah, it's quiet and it's drama free over here. Yeah, we try to keep the chat clean, you know. And then during the hearings, my style is I just play the feed. I'll just pull up chats as we go along. I boost the audio so everybody can hear properly, and that's what we do. That's what we do. That's what we do. Excuse me. I don't know if anybody caught last night's very late night stream. We had a lot of fun. We went back and looked at basically the hearing that blew everything wide open. That May 3rd, 2022 hearing. I'm sorry, 23. Ugh, I'm still waking up. But we had a really good time last night going over that. So if you haven't caught that, go back and check that one out. We just kind of replayed that. I mean, we had the Turtle Boy April 18th, 2023 article, the first Canton cover-up, part 1. And then basically May 3rd, I mean, almost 2.5 weeks later, the hearing that kind of blew everything open. And that's when we saw the chalks in the courtroom with John O'Keefe's bite and scratch mark injuries to his arm. Stephanie says, I can't believe she's going through this again. I just keep having the repetitive image of the FBI walking down through the courtroom and shutting down the trial. I wish, I hope that's going to happen, but Steve says, I got to focus on work. I'm going to catch you later, Brian, in chat. Yes, Steve, have a great day. Thanks for popping in. Go check out the LV Cops, YouTube channel. We've had them live in the studio before. Jane says, good morning. Praying that the whole truth comes out. Free Karen Reed. Absolutely. 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 Oh, boy. So we are in a delay. And I appreciate everybody popping in. Again, I'm sure everybody's watching everybody's favorite law tuber this morning, which is great. Let's see who's on right now. Is Andrea Burkhardt on? I like watching her. Let's poke in on Andrea, see what she's up to. We'll wait for this. Andrea, I hope you don't mind. I'm going to play your... Make sure to sub up to her.
Of these witnesses, they've already seen how they present, how they maneuver, and so forth. I remember, I can't remember her name now off the top of my head, but the DNA expert who did, boy, was it the mitochondrial DNA or was it the dog? Was it testing for the dog and found the pig? Now I can't remember off the top of my head. I have to go back through my notes. Got them all right here.
I like
Gonna
Andrea.
be reviewing that as we get ready for trial to get started. Have everything ready to go so we can have a good comparison of what happened last time versus what is happening this time. Anyway, I can't remember the specific witness off the top of my head, but I just remember it was one of the DNA witnesses. It was she was a female. I think she was the one from UC Davis. And anyway, she was very very slippery, not going to really give the defense a whole lot when it came to acknowledging limitations, conditions, and things like that. And so that's pretty normal. It's pretty normal. Experts don't typically like to get on the stand and look like what they do is unimportant. I mean, this is something that they have spent their lives on. They've spent their careers on this. To get up and be like, yeah, actually, I know I've been doing this for 25 years, and between us, it kind of is junk science. Like, no, you're probably not going to get that. So kind of important to know if the defense expert, Mr. Miyasako, or is it a Commonwealth guy? Now I'm confused. I know I remember I remember it's DNA, but whose witness it is and what exactly he's going to testify to now, I just don't remember. Like, things have gotten very chaotic. Things have gotten very chaotic. So we're still staring here at the fan, guys. We're like 23 minutes late getting started in court. It was supposed to be at 10 a.m. So I got to sleep in a little bit, which I definitely appreciate. I get to ease my way into the old early morning schedule, trying to watch the East Coast trial over here on the West Coast. Never the funnest thing, but I see Melissa Dodson is here, busy in the chat, gifting away all of these memberships already so early in the morning. Thank you so much, Melissa. You are such a good supporter, and we really appreciate what you do and how you share that with the other folks who are here with us this morning. And we do got a pretty big crowd for still waiting on this fan. So maybe we'll get started pretty soon. Hard to say. Emmy G has given us a super sticker. Thank you so much for that, Emmy. And we have a first question in from Melissa. Melissa Dotson, since Brennan has announced that he intends on using Karen Read's public statements during trial, do you think this boxes Karen Read into taking the stand now? This is a great question. Now, you guys might remember I am very heterodox when it comes to the idea of the defendant testifying. Common wisdom out there is don't do it if you don't have to. Don't put them on the stand. I disagree with this. I am always in the camp of if you can, if it's not going to blow up your case for one reason or another, put your client on the stand, put the defendant on the stand, because the reality is simply the jury wants to see them. And even though the jury is instructed that they're not to hold it against them, they do. They do. It is just how they think. It is part of the biases that people have. People sit and think to themselves, if I didn't do it, I'd get up on the stand and tell you that. And of course, it's all hypothetical. They haven't been in that situation. They don't actually know what they would do. But it's just the way people try to put themselves in the shoes of other people. And just imagine, try to understand their motivations and thought processes and things like that. So not testifying, it works against defendants. It's not supposed to, but it just does. And so I'm in favor of Karen testifying regardless. Now, having said that, the fact that she didn't do it last time, it's kind of turning out to maybe be in her favor, because she's still got that card that she can play in this trial. But these interviews do change. They do change the situation a little bit. And so I think the answer to this question is really going to be it depends. It depends. The reason why is because you have with out of court statements this doctrine that's called the rule of completeness. And so the idea is if one party wants to bring in a part, just one part of a much larger statement, then the other party gets to say, gets to require that you need to also put in the bits that are necessary to fairly understand what was being said here, the context that's critical. How much of that is going to apply to these interviews? It's kind of hard to say. Does it mean they're going to be able to put defense is going to be able to put in the entire interview if the Commonwealth, uses like one sentence that she said? Probably not. But it just really depends, doesn't it? If the Commonwealth wants to put in something where Karen is talking about her thought process in the days immediately following it. I'd had something to drink. I wasn't sure. I thought maybe I could have hit him. Maybe I backed into him, nudged him or something. Remember she made those comments in the ID, the one that was just the body in the snow that was just out there. Commonwealth just wants to put that in. Well, does that mean the defense should be able to put in all the stuff where she says repeatedly, I didn't do it. I know I didn't do it. It didn't happen. I didn't hit John with my car. Yeah, I kind of think they should. Because it would be misleading to present this one piece, this one little chunk of something that she said, devoid of all of that context, where she says, now, I know and I'm not confused. And I've had all this time to think about it and remember it and look at the evidence and so forth. And I know I didn't hit him with the car. Yeah, it would be misleading because it sounds a lot more potentially self-incriminating than the context as a whole. So that's a big it depends here. How much of Karen's own story can the defense get in just through the rule of completeness? If they can get in the bulk of what they want the jury to hear from her by using her out of court statements, then they don't need to put her on the stand. They don't need to. They can just rely on the same interviews that the Commonwealth is relying on. Now, having said that, how expansively do we think Judge Cannoni is going to interpret the rule of completeness in this context? Do we think she's going to be generous to the defense on this? Yeah. Yeah, I'm skeptical. I'm quite skeptical of that. So I think, yeah, there is the potential that it puts her in the position of needing to potentially get on the stand to explain. If the Commonwealth goes through and cherry picks things and the defense is not allowed to use the context from those same interviews to be able to explain it, then yeah, the pressure's on. The pressure's on because there's a risk. There's just a risk that the misleading works, that the taking it out of context, presenting it, as something more compelling than it is, that would work. Where do we see that? Oh, I am so glad. I am so glad the world is finally getting to see the evidence from Delphi. hmm The confessions, boy, am I glad. As heart-wrenching and awful as it is to listen to, I'm really glad the world is finally getting to hear the phone calls, the confessions. Maybe I did it. Oh, yeah, real incriminating stuff there. Maybe I did do it. But when you take it out of context and you distort it and you present it as he confessed 60 sometimes, makes it sound a lot more compelling than it is. So that's the risk. That's the risk to Karen. So I see here somebody tagged me in a post from Dr. Turtleboy. After 2 weeks of bugging and asking him, Clerk Jim McDermott alerted my attorney via email at 9:45 that he needs me there by 11 to hear our motion to exempt me from the sequestration order. I live an hour away, so I had to get ready and just left. I should be there by 11:15. Interesting. So last minute, not very organized, not very coordinated. Is that on purpose? You know, who knows? Do want to give people the benefit of the doubt, but yeah, you need to be here. You need to be here in an hour. Not really the best logistics on the part of the court. So does that mean we're waiting till 11? Is there nothing else that we're taking up? I don't know. I don't know. Yeah, that was from Keely H. I tagged you in Turtle Boy's tweet. Interesting. That is definitely interesting. So we know that's on the docket. We know they'll be addressing that, but what, if anything else? Who knows? Who knows? Melissa Dotson gifted 10 more Andrea Burkhart memberships. Melissa, you are just the best. Thank you so much. You are so generous in your support. The rural juror, the Commonwealth wants to sub him for the OG DNA expert. Yes. Oh my gosh. Thank you for the reminder. I can't believe I forgot this. This is Carl Miyazaki. This is who he is. Oh, thank you for the reminder. This is the one that has the confrontation clause issue. The original DNA analyst who did the testing, did the swabbing and got the results and all that stuff. That DNA analyst, they say, has some kind of conflict. I don't remember if it's medical, but isn't going to be able to appear in this trial. So they want to bring in her supervisor. And so the supervisor then is going to testify about his own independent opinions based on his review of her work. Here's the problem. Here's the problem with that. There has been a ton of case law in the U.S. Supreme Court, not to mention, all of the different circuits, but very specifically in the U.S. Supreme Court for a number of years, dealing with exactly this issue with experts and the extent to which one expert can testify on behalf of another expert. So the very first case, I'm going to look up the year. The very first case where this came up was in 2011. 2011, Bull Cumming versus New Mexico. And so this was a situation where you had an analyst, did some tests, ran some things through a machine, got results, and then didn't testify at trial. Somebody else came in and testified to those results that came in from the machine. And the U.S. Supreme Court said, no, you don't get to do that. The one who did the testing is the one who has to testify to it, because they're the ones that went in and got the information. They're the only ones that know if they did the steps correctly, if the machine was functioning properly, if they sanitize the area, like all of those kinds of details. The individual who did the testing is the one who has to testify to it. And so then there has been all kinds of wiggling and trying to work around that requirement that's happened in the 14 years since then. And so where this caught my attention was it came up because Hank Brennan cited this case in his motion. He cited, where is it here? Williams versus Illinois from 2012. It's the very next year after Bullcoming. And so in that particular case, they didn't even actually have a majority decision. They had a plurality. So that means it's very difficult to go in and sort out like what actually is the law resulting on this, because they didn't have a majority of the court on the reasoning that supported the outcome. So they had some justices, 4 justices basically said, we think this was okay under these circumstances. It should be admitted. But then you had at least one other justice that agreed, yes, it should come in, but they had a different reason for it. So there was not a coalescing around what the rationale was for this particular decision. So that was what Mr. Brennan relied on as his legal authority for why I should be able to do this case from 2012. Well, what's the problem? What's the problem? The problem is there was a case last year in the U.S. Supreme Court, Smith versus Arizona, where the U.S. Supreme Court specifically said that those things we said in Williams, that plurality that was not really binding on anybody, but we were sort of, confused about how we were going to decide and had these different opinions and stuff. Yeah, we abrogate that. We're not following that. That's not the law. And the problem here is that what the state's trying to do, what the prosecutors are trying to do, is they're trying to get this work product in front of the jury without having to have the person who produced it, subject to cross-examination for it. And they're trying to do that through all of these different mechanisms. And with the supervisor review, this technique that Mr. Brennan is trying, what they do is they try to squeeze it in through the expert witness rules, where experts, they can often testify to the basis of their opinion, even if it's not otherwise admissible in evidence. So there's different state rules about whether you can or can't do that. Massachusetts, for what it's worth, has a little bit more of a limited version of that, which has an effect on the Canton police audit, which maybe we'll get to next if we are still going to keep waiting for the court and staring at this fan. But so that's how they try to get it in. They say, well, this was the basis of his opinion, so he's allowed to testify to that. Doesn't mean that we're accepting it for its truth. We're just saying that that's what he relied on, and this is what experts ordinarily rely on, and so therefore, he can disclose that as part of the basis of his opinion. And the U.S. Supreme Court said that's a bunch of shit, because you have to assume that it's valid. You have to assume that it's true and it's correct and it's legitimate if he's gonna be relying on it. You don't get to pretend like you're qualifying it in this way when you are not in fact qualifying it in that way. You're just using somebody else as a mouthpiece to get in work that they didn't do, and to present it as valid when it hasn't been tested through the trial process. So Smith v. Arizona, they very specifically said, no, it's a confrontation clause problem. If you go in and you get in another analyst's results through a non-testing supervisor or other type of witness. Are they going to try to wiggle around that? Oh, of course they are. Of course they are. Of course they are. They're going to continue to try to wiggle around that. Well, but we're not going to bring in her actual report or her actual results. It doesn't matter. He's going to have to testify to them and that he relied on them. Why? Because he didn't do any testing himself. That's why. So it's not a meaningful distinction, but they'll still try. They'll still try. Now, one of the issues with the confrontation clause is that what it means is that you can't bring in testimony, out of court, hearsay testimony, somebody else's report, somebody else's opinions, etc. You can't bring in their out of court testimony unless there has been a prior opportunity for cross-examination. So here's where the Commonwealth does actually have an argument. They do actually have an argument. She testified in the first trial. They had their opportunity to cross-examine. So why they haven't just presented the actual law, like the law that is current, the law that has not been abrogated, and acknowledge, yeah, it presents some confrontation problems, but we can overcome those because they had the prior opportunity to cross-examine her at the first trial. That's the argument. That is the legally sound and ethical argument to make in this position. So why are they not making that? I don't know. I'm not a prosecutor. I have a very hard time. I have a very hard time, a lot of times, getting into the mind of a prosecutor and why you got to try to distort and mislead and act like the law is something that it isn't. Now, here's what I could anticipate. Maybe, here's a maybe. Here's a maybe why they don't want to go down that road. Because remember, a lot of this evidence and testimony, this was disclosed late. It was disclosed late by the Commonwealth. And so, is there an argument maybe on the part of the defense that, we didn't actually have a full and fair opportunity to cross-examine her because we didn't even have the basis for her opinions on any of this until trial was already underway a week before, something like that. We didn't have time to get it to our expert for them to be able to review it. We didn't have the ability to do our own independent testing to try to verify because you were late. And so that's why we didn't have a full and fair opportunity to cross-examine her, because we were sandbagged. Now that we've had this evidence for, a year plus, now we've had the opportunity to do that. And now we have some questions that we want to ask this analyst. Maybe that's why, because you're trying to sort of preemptively foreclose an argument like that. You messed up, so you just try to pretend the law is something that it isn't. I'll tell you, for a judge that's gravely alarmed about candor to the tribunal, the representations the attorneys make, the need to be able to rely on them and what they say. If I'm a judge, I'm a fair judge and I'm an even-handed judge, I'm going to be pissed. I am going to be pissed about this motion that the Commonwealth has given me. Rule 11, the obligation to, certify the reasonable good faith basis of what's in your pleadings, what you file in court, does not just apply to facts. It applies to the law. That to the best of your knowledge and ability, the law that you've cited, it's good law. Your arguments are legally founded. And it's just as important for the judge to be able to rely on the attorney's legal briefing as it is their factual briefing. Because if I can't rely on you to correctly accurately represent what the law even is, then that means I got to go through and I got to research all of this stuff myself every single time. Every single thing I have to decide. I can't rely on you. You might be lying. And then if I rely on you, I've relied on an erroneous legal argument. The law is not what you said it was, and so it's not the accurate foundation for my decision. And that's setting me up to get reversed on appeal. So I'm going to be really pissed if this motion comes across my desk. We'll see, won't we? We'll see. We'll see how gravely alarmed Judge Cannoni is by this this particular issue. Thank you so much, the rural juror, for that reminder. I can't believe I forgot that. It's not even that early, but that was notable, I thought, when that happened. The rural juror, Bev, definitely won't be giving KR a single scintilla of room on top of what HB says is complete. She only take HB at his word, not the defense. Sure does seem that way, doesn't it? Sure does seem that way. The defense has had so much time with her by now, and they have gotten the flavor. They have seen how she is. They know how she is. And I definitely would hope that they have learned that they just can't count on her to be reasonable. They can't count on her to be even-handed, to apply the same standards to both sides. And so they need to make their record every single time. I hope they are prepared for that. I really do. Because yeah, if Hank Brennan is going to get up there and say, well, this is complete. Yeah, she might buy it. And so what do they need to do? They need to be prepared to file into the record an offer of proof of here are all of the pieces of the interview that we think are implicated by what the Commonwealth wants to do. Get that in the record. No, it's not going to help Karen at trial. And I know that's something that is very frustrating to a lot of people. I understand. I do. Process is the punishment in so many ways. It's a way to get the pound of flesh. Get the pound of flesh and let the Court of Appeals sort it out. It seems like a very inadequate and unfair remedy to a lot of people. And I can appreciate that perspective. I definitely can. Nevertheless, it is what it is. It's what we've got. It's what we're going to be dealing with. Oh, here she comes, finally. No sound yet. Come on, Law and Crime, give us some sound. I'm going to check and see if maybe one of the other channels has got sound yet. Looks like not on NBC 10.
Morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti.
Morning, Your Honor. Victoria George from Karen Reed.
Good morning, Ms. George. Good morning, Ms. Reed. All right, so I appreciate getting those lists on what we all thought were still either under advisement or needed to be heard today. There's one that it seemed that, all right, we'll start, first of all, let's start with the defendant's renewed motion that is not in writing. I think, Ms. Little, I think this was your motion for a forensically sound copy. You wanted to be heard on that?
Yes, Your Honor.
You did not file anything new, right?
No, just the motion
Okay.
for reconsideration.
When was that filed? That was filed a long time ago, right?
Yes.
Okay.
It was prior to the motion.
All right.
Your Honor, the defense respectfully requests that this court reconsider the portion of its February 18th, 2025 order denying defendant's motion to compel the production of a forensically sound copy of the Sallyport video surveillance footage from January 29th, 2022. The court obviously understands the importance of establishing the bona fides of the Canton Sallyport video in this case. The court sat through trial. You watched the testimony regarding the inverted video. The court initially denied the request for a forensically sound copy because I believe the court indicated it did not have an affidavit from an expert suggesting that the procedure proposed by the Commonwealth and objected to by the defense would result in the destruction of metadata. We have since provided the court with an affidavit from our expert establishing that if the Commonwealth engaged in the protocol that they proposed, namely simply dragging and dropping files from the Canton Police Department computer onto a USB drive, then all of the associated metadata would either be destroyed or otherwise unverifiable. And of course, right after we filed that affidavit, the very next morning, the Commonwealth went ahead and dragged and dropped the files from the Canton Police Department computer over to a USB drive. That damage has been done. It can't be rectified, but there may still be some metadata and available evidence on the Canton Police Department computer that our expert can glean if that data is properly imaged. The import of this video surveillance cannot be overstated. This is a seminal issue at trial. I have conferred with our expert. I do believe that there's a chance that we may still be able to obtain some relevant information. And so we're asking that the court order this. I would also note that after the hearing on this specific issue, the Commonwealth produced a new report. That report was dated February 27th, 2025. And in that report, Canton Police Department Sergeant DGM Pietro claims for the very first time that he was responsible for downloading all of the Canton Police Department surveillance video, in this case, onto the detective drive at issue. So that's everything from January 29th. That's incredibly important. We don't have all of that information, and we're asking the court to order that that be properly imaged for our review.
Okay, thank you, Mr. Bryan.
It seems the defense characterization as forensically sound is fluid. It's difficult to follow. What is clear is that we invited them to come to the Canton Police Department, bring their expert, download anything that was on the DVR, which nothing existed. And then we further invited them to download the detective file. They had over a month to do that. They declined. That invitation has been ongoing. It's been constant, and it is current. If they would like to go to the Canton Police Department with their expert and download any of the detective file and see what exists, they're welcome to do that. So if they want a court order allowing them to come, which they don't need because we've invited them continuously, we'll agree to the court order. They're welcome to come anytime.
So is the Commonwealth now agreeing that we can forensically image the Canton Police Department detective file? Because we've been in our request.
Okay, so I really don't want you talking to each other. I want you talking to me. All right, so you asked the question to me. Answer it, Mr. Bryan.
The defense cannot download the entire detective file because it contains files wholly unrelated to this case. And it would then intrude upon private information and other investigations. They can go to the detective file and they can download everything to do with this case. But they cannot have a photo image of the entire detective file of the Canton Police Department.
Okay, thank you. All right, so the next motion we're going to do is just the motion for the view. I had asked defense counsel to propose something about how Ms. Reed will get there. Have the two of you talked at all about how we're going to do our view? Two sides talked?
We haven't talked about the logistics. I'm happy to do that. I don't think that it's a very lengthy conversation between the Commonwealth.
Right, but we have to make arrangements, so that was something that I asked you to figure out. You say Ms. Reed wants to go on the view, she can go on the view. How do you propose that's done?
The simplest way would be for her to, obviously the jurors would be transported the exact same way that they were transported last time. We were on a bus. As I stand here, I can't remember if we were not on the same bus as the jurors.
Yes, we were.
We were just separated by seats, by
Right.
distance. I don't know that would be the best protocol. I think the better practice would probably be for the defense team to arrive at the same time, follow the bus in a separate vehicle, which we can provide. And Ms. Reed would be separated from the jurors the same way that the defense counsel was separated from the jurors and the Commonwealth was separated from the jurors, but just be there and able to observe the same circumstance that we observed last time.
So I'm not going to allow all defense counsel to come in a separate vehicle because then it will be the Commonwealth in the bus with the jurors. We need defense counsel. One defense counsel can go in a car then separately with Ms. Reed,
That's
and
fine.
the rest will be on the bus.
That's fine.
I do need you to talk to figure out when you want to do this view. Did you want input, Mr. Brennan?
The only issue that was of difference was whether or not the motor vehicle would be at the address. The only reason I had reluctance, I thought it was unfairly prejudicial to the defense. If they decide,
They want it, right? You want the vehicle there at the time?
We do.
if they want it there, then I'll be agreeable.
Okay.
That was my concern at the time, but if that's that request, I'll agree to it.
Okay.
The date of the view, I didn't know if the court wanted any confidentiality in the date of the view. I would like to talk to.
So why don't I see counsel at sidebar about this anyway? All right, so on the defendant's list, I don't understand the motion regarding Dr. Welcher, because that's been decided. So why is that here on this list? Is it erroneously on the list?
It's not erroneously, Your Honor, but Mr. Brennan and I spoke about it. We have an agreement that will obviate the need for the court, which is my presumption. Mr. Brennan is going to state it, and that would be my suggestion to Your Honor, and that we can move on to the next matter. We've reached agreement.
Okay, what's the agreement? What's the agreement?
The agreement is there's going to be a redaction to the PowerPoint presentation of Dr. Welcher, specifically page 37. There was, according to Attorney Brennan, an erroneous remnant on 37.
Okay, so why don't you just provide me with the new slide so I know what it is? Okay,
I will do that.
all right, thank
Thank you,
you.
Your Honor.
Okay. So Lieutenant Wing, docket 607 and 658. So what I want to know about that, Mr. Brennan, before we begin is, do you have the new report of Lieutenant Wing?
I do. I received it last night. I haven't read it, but I discussed it with counsel. I understand it's just minor edits to the original report. So that won't delay any hearing on this.
All right, so you're prepared to go forward?
I am.
All right, I'll hear you.
Your Honor, the defense proposes Mr. Wing as a dog bite expert. I think it is too late to ask for a Lanigan hearing. The trial's upon us, regardless of whether or not I think I have standing for it. I do not want to delay this trial in any way. However, there are concerns about the qualifications of Mr. Wing. He has no experience in pattern recognition analysis. I see no training on his resume. I will not hold the defense to the standard they've tried to employ, that he is not a medical expert, nor will I rely on Dr. Russell saying she's the only qualified individual in the country, but rather this person should have some qualification to come into court and give an opinion that a abrasion is supposedly a dog bite. It doesn't appear that Mr. Wing is a certified trainer. It doesn't appear that Mr. Wing has ever testified in court before. And so to expedite the matter, rather than look or seek a Lanigan hearing, I think it would be helpful to have a short voir dire regarding his qualifications before he's presented as a witness, so the court can determine whether or not he is in fact even a qualified witness in this case.
Thank you, Your Honor. With regard to the report, I just want to underscore that there are changes and I discussed these with Attorney Brennan, but I want the record to be clear. There was an objection to the original report of references to Dr. Crosby. We removed those, so those are fairly substantial.
Are there any other changes to it other than the removal of Dr. Crosby?
There are, but there, as Attorney Brennan indicated, they're minor rep parlance, et cetera, but otherwise it's the same substance.
Okay. So why don't you provide me with the new or redacted one as well, and I'll take a look at it.
Right,
Okay.
that has, I will do that, Your Honor. I'll provide the court with that forthwith. The second is on the substance. Lieutenant Wing is extraordinarily experienced. You will see that in his report. The summary of his experience, because it would take a lot of time to go through it. For several years, he's been one of, if not the country's leading experts on training law enforcement with regard to the use of canines, not only with bite and hold techniques, but also with what are called washout dogs, which are very much similar to civilian, some call them pet dogs. He has extraordinary experience with wound recognition, Attorney Brennan respectfully is incorrect when he says he doesn't have experience with pattern recognition. His experience is extraordinary in that regard. Your Honor will make her own judgment, but the report clearly establishes his pattern recognition. His methodology, unlike that of Dr. Crosby, is stated in his report, and in addition, he cites 2 specific studies for his report, including pattern recognition. And the whole topic of pattern recognition was well established through Dr. Russell. So Your Honor will see that as well. My last category of points to make, Your Honor, is this. The timing of this report came in light of the court's ruling on Dr. Crosby that a non-medical doctor can opine on wounds to humans. And we did make a motion for reconsideration with regard to Dr. Crosby, and understanding the court's schedule and other matters, given that there was not an ability to have that motion determined, we then decided that we had to submit the report of Lieutenant Wing. We want to make clear that Lieutenant Wing is being offered not as a sur rebuttal, but as part of the defense's case in chief. And it is part of that in light of the March 6th order of the court with regard to Dr. Crosby. The aspects of behavior in combination with a wound recognition is different from Dr. Russell. There is overlap, but it's different. And the bottom line here is that the approach of Lieutenant Wing and his qualifications exceed that of Dr. Crosby. And my request, Your Honor, is I do not believe there is at all a need for any kind of a hearing. Again, Your Honor will make that judgment when the court believes that, notwithstanding the qualifications of Lieutenant Wing and his methodology as set forth in his report, we would respectfully request that we have a voir dire hearing on Dr. Crosby. We have made that request of Dr. Crosby.
That's another motion. That's what we're going to hear now.
Understood. And I was just going to say, I am not going to get into the basis for that. I just wanted to, because...
Just go ahead. Just move on.
Yeah. So my request would be that a determination on whether or not there's a voir dire of Lieutenant Wing abide the motion in the discussion. So in conclusion, Your Honor, we respectfully request that have a voir dire hearing on, at a minimum, wait for that determination until the court reads the report of Lieutenant Wing.
Right.
Thank you, Your Honor.
Okay. All right. So there's also a motion for reconsideration regarding Dr. Crosby. I can tell you regarding reconsideration, I've found that he is an expert. I am not going to reconsider whether or not Dr. Crosby is an expert. I'm not going to reconsider whether he can testify as something is consistent or inconsistent with dog bites. But Mr. Brennan, I don't see how you're going to have him testify as to whether these marks could have come from Chloe, the specific dog. I think that you can certainly talk about measurements that may have been made, but I don't see how he can testify that this either was or was not this particular dog, particularly in light of the most recent National Academy of Science report that found that no evidence of an existing scientific basis for identifying an individual to the exclusion of all others via bite mark evidence. So what do you want to say about that?
Your Honor, there's a distinct difference between inclusion and exclusion. The National Academy of Forensic Science was an extraordinary study, well respected. I've read it many times, and that is a consensus among experts that teeth structure can in many ways be similar. So it is unfair to conclude that a particular person or a particular dog should be included or identified as the person who left that particular pattern. I agree with that wholeheartedly. It is different in kind and not within the realm of that study or any other studies that I've seen to exclude a person or a dog as the contributor of that bite. And here, there is definitive evidence to clearly show and base an opinion that the dog named Chloe was not the cause of those wounds. That is the whole purpose of having the mold of Chloe, which is done with humans routinely, often, orthodontists, dentists, restructuring. The spacing itself is so distinguishable between the molds and the spacing on Mr. O'Keefe's arm. It is an objective, a specific, and a substantive basis to draw a conclusion that there is no way to a degree of certainty that these wounds were caused by Chloe's mouth. In particular, Dr. Russell had opined not only that the bites were consistent with a dog wound, but she also opined about molars in different parts of the mouth. And since the defense has decided to likely identify particular teeth and structures as the basis to say it's comparable, consistent with a dog, we should be able to counter that in rebuttal, not in our case in chief, in rebuttal, that these molds showed to a reasonable degree of certainty that these wounds could not have been caused by Chloe. So it's exclusion, not inclusion.
It's an uphill battle for you, I'll tell you that. I'll hear from Mr. Wilson.
Thank you, Your Honor. I can go through this quickly. The National Academy of Science, the 2009 report Your Honor is referring to, there is no finding in that exclusion's okay, but inclusion is not. There's nothing in there to support that proposition. That's number one. Number two, with regard to the opinion of Dr. Crosby, he did use a mold, but he didn't use the overlay. In the NAS, I'll shortcut it, 2009, the only way you even get to discuss it is you have to have the mold and the overlay. Dr. Crosby doesn't have the overlay. So even not considering the first point I made, where that's allowed for humans, you need a mold and an overlay. So there is no basis in science for the proposition that with certainty this could not be Chloe. So in sum, the inclusion-exclusion distinction that Mr. Brennan tries to make is nowhere rooted in the NAS study. And the point that Your Honor made and that we have made consistently is that there's little difference between inclusion and exclusion when you get to the methodology that's employed. So we, Your Honor, would support what Your Honor's comment was in the beginning, and that is there should be no discussion with regard to Chloe on inclusion or exclusion basis. Thank you, Your Honor.
Did you want to reply?
I would simply suggest that there is no authority that I'm aware of that prohibits exclusion, none. And as a predicate, and I know it's a side matter, the idea of Chloe as a predicate, that requires third-party culprit. And so before there can even be discussion about that, there would have to be an offer of proof that we have not seen and has not been presented. So it really should be irrelevant. But if the defense is going to try to bring it up, it's going to become a live issue. And if we have an obligation or we have a need to rebut, we want to fully rebut any of those claims.
Okay, which is why originally I was going to hear this motion to reconsider after the defense presented their witnesses. So, all right. Thank you. The substitute chemist, is there any objection to the substitute chemist? It's Commonwealth's motion 663.
No, Your Honor.
Okay, so Jim, 63 is allowed.
Yes, Your Honor.
So you both have motions that are similar regarding, it's the Commonwealth 669 and Defense 670, I believe. It's about the audio visual aids and giving notice. So you're both in agreement to give notice to the other side before you use anything, and have you done so with regard to openings?
The Commonwealth agrees to give notice. We've provided a number of clips of statements that we seek to use during the trial. I hope to narrow the ones that we're going to use specifically so the defense could have more notice of it. We have a clip that we'd like to offer in the opening. I'm not sure if our office has provided that to the defense. If not, we'll do that shortly after the hearing.
Okay. Who's arguing this for the defense, or who's telling me what's
I am,
going
Your
on?
Honor. We're happy to provide notice. We have not yet received the particular audio clip that the Commonwealth intends to use during opening, but we're happy to provide any visual aids that we intend to use as soon as today.
All right. I'd like to see what you both intend to use in your openings, because whether you agree with it or not, I have to make sure that it's admissible, that I know it will be coming into evidence before I let you put it up there.
That really is the
This is
motion.
for the court. The Commonwealth will provide a copy to defense. That's
Okay, thank you. Can I have the defense what you intend to put up?
This is a single photograph, Your Honor. I'll provide it to the court immediately after the hearing.
Okay.
Your Honor, I'll add that there are a number of statements that we have clipped. We, with the court's permission, would like to provide an entire package to the court so you can have an opportunity to view if you wanted to.
Thank you. So I need the defense to look at this before the end of the hearing, because I don't want to bring everybody back tomorrow if you object to what the Commonwealth intends to put in their opening. Did you tell them what it is? Like, is it something that they already have?
They've had the materials, the interviews in total, but we've clipped the pieces that we want. It's been an ongoing process. I understand my office has sent a slew of those clips to the defense.
Okay.
I want to narrow it down. We're not going to use all of them unless there's a rebuttal portion, but I want to narrow down what we're giving them. But we've been over-inclusive in what we intend to provide.
The Commonwealth provided at least 44 clips. I'd ask for whatever they intend to actually use in their opening so we can look at it for.
I think that's what they just said. They're just going to
yes.
give
We'll
you.
give them the file name and if the court takes a recess, we'll give them the file
Yes,
name.
I'd like to do that just in case there's an objection, or I can bring you all back tomorrow or Friday, and I don't really want to do that to you. So,
Thank you.
all right, so we'll just take a look at that. Okay, so that sort of also covers, I guess, the the Commonwealth's motion regarding the use of extrajudicial statements. And if you hang on while I grab that. Is there an objection to that motion?
No, Your Honor.
Okay,
Can I make a note?
yes,
So,
please.
the defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case. I don't expect there'll be any emphasis or drama in the presentation
Okay.
of text messages, but I think an independent reader is fairer, more objective, and we'd like to have that independent reader take the stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
All right, how are you going to find this person?
But we could have somebody playing close from the state police, or we could find somebody that's agreeable to the defense. But I think it would be best if we have an independent reader who's available throughout the trial to play that role.
Okay,
May I have a moment, Your Honor?
yes.
Your Honor, thank you for the time to consult with my colleagues. I don't think we're in a position to agree or disagree at this point. I don't know exactly which text messages or which conversations are intended to be independently read. At the last trial, they simply came in through the person that found the text messages. Mr. Lally asked, I think, Mr. Garino, I can't remember his first name, Mr. Garino to recite the messages from both sides, and that was done pretty effectively and expeditiously. But unless I know more about exactly what the theater of having an independent reader is going to be like, I can't really weigh in.
Go ahead.
May I?
Yes.
Wherever there's a witness involved in the conversation, if those text messages are admissible, it would come in through the witness. Text messages between Mr. O'Keefe and the defendant, there is no author of those. And so we will introduce those text messages, the admissible ones, at different parts in the trial when they become relevant. So it's not sufficient to simply have a state police officer who is not a witness to those text messages to come in and read them continuously through the trial. Mr. Garino is an independent witness in this case. To bring him back regularly as a police officer, I think is creates the wrong impression. I think objectively we can have somebody come in who simply reads those text messages when they're appropriate to introduce.
I would disagree gently with Mr. Brennan. That's exactly what the proper protocol is. If Mr. Garino is the one who found it, he's a state trooper, he found the text messages. He was the one who downloaded the data. He was asked about those text messages previously. I think having him come back, and it doesn't matter how many times he comes back, he's paid by the state. He can come back 5 times or 1 time. But to have somebody else come in or other individuals come in to act as readers, I think that is not in keeping with the ordinary course of presentation of the evidence. It just doesn't make sense to me to have a reader come in. It seems to add a theater to the text messages that are inappropriate. I don't know who these individuals would be, and the text messages are admissible because they're their statement of a party opponent, and the other is the context of the statement of the party opponent. So I don't see any reason to change the protocol that we had last time.
All right. If I were to allow an independent reader, do you have a male and a female? Or would it be a male reading a female's responses?
I haven't identified anybody, but I can get a male and a female.
All right.
And that's exactly what we don't want. I think that's inappropriate. It's not going to be Mr. O'Keefe, and it's not going to be Ms. Reed. The text messages speak for themselves. The jurors should be able to analyze the words that are on the page, the text messages as they were written and drafted, not the inflections and the repartee between 2 independent people with motives that may or may not be consistent with the text messages. As we all know, it's a very, very different circumstance to have a text message communication with someone and have a conversation with someone, for instance, telephonically or verbally. People talk about it all the time. Things get lost in text messages. Having them read by a state trooper who found them.
So it can be perhaps not a state trooper. That's all. I understood it to be to take out all infliction and completely that.
Right. I heard Mr. Brennan say the same thing. I don't know that that's actually what's going to happen. And this lends itself to sort of a theatrical presentation that's completely unnecessary and could be incredibly objectionable. And then once it's done, it's done.
All right. I will consider it.
There'll be no inflection. That would be inappropriate.
Thank you. All right. Defendant's motion for specific discovery, paper 638, Jimmy. All right. Who's arguing it?
Yes, that's me, Judge. Good morning. Before court today, Mr. Brennan and I conferred, and I think we've largely reached agreement. The only numbered items on which we do not agree are 3 and 4, which are related. I will say as a preface that we are withdrawing request number 8. And with regard to request number 7, we've agreed on the following language, Judge, which I would read into the record. Number 7 would be any indication of a witness willing to change testimony in exchange for any consideration. With that, I would ask the court to allow the motion with regard to 3 and 4. I believe that we should receive information if there's a witness who has expressed to the Commonwealth either a refusal or a reluctance to testify in this matter or to cooperate in any way.
Okay, there's no authority for that in Rule 14, correct?
We believe that it's consistent with Rule 14, which is why we've made the request.
Okay, where? Where in Rule 14 or the reporter's notes?
Relevant and discoverable. It applies to a witness's credibility, motives, intent, and that's the basis on which we make the request.
Okay, I'll hear from the Commonwealth.
Number 5? Yes, with regard to number 5, we also talked about modifying the language. Mr. Brennan had taken it down for us. Any information of any witness regarding promises, inducements, or rewards to that witness.
Okay. Mr. Brennan, regarding 3 and 4, what's the Commonwealth's position?
Your Honor, that does not go to motive or credibility. It is not within Rule 14, should not be discoverable. It's irrelevant. It doesn't show any bias on behalf of the witness if they had any reluctance or concerns about testifying. I have been very broad in my agreements regarding discovery. Anything that is Rule 14, exculpatory, even their specific requests, which extend beyond Rule 14, I am more than happy to give them. But I think 3 and 4 are personal, irrelevant, and have nothing to do with bias or credibility.
Okay, thank you. All right. The ARCA witnesses, motions regarding that. So where do you stand, Mr. Brennan, with what has been provided and what you might think has not been provided?
There are 2 issues. There is the discovery that we have requested in the past. At this point, I stand unsatisfied with that discovery production. And then secondly, there is the limitations that should be imposed upon ARCA based on what has been provided pursuant to reciprocal discovery. I'd like to start with the second part, and that is we have a little chronology. December 5th, 2024, we submitted docket 442, Commonwealth's motion for reciprocal discovery, which was allowed by the court. There were a number of other motions which led to March 27, 2025, docket 640, Commonwealth's motion to compel reciprocal discovery of ARCA witnesses or to exclude their testimony. And then the next day, on March 28, 2025, the defense responded with docket 642, which was a response to docket 442. And so what we were looking for, not only Rule 14, but more specifically our discovery motion, was information from ARCA that would make clear the relationship between the ARCA witnesses and the defense back from its inception. It is important because that information, a thorough vetting of the information, may be a basis for the Commonwealth to inquire of these ARCA witnesses, if they're called, about candor, truthfulness, and full disclosure. And so while we've received some answers to our questions, we want a full vetting of that history. On a prior date, the court suggested that perhaps we could have a voir dire, not regarding their qualifications, but regarding this very issue about the relationship between the witnesses and the defense. That is one viable option. My concern specifically is if they are subject to a voir dire the day before their testimony, they're traveling from out of state, they will not have with them documents and other items which are necessary for the Commonwealth's review and likely use during the examination. And so if the court was to maintain there would be a voir dire the day before the hearing, I would ask for an order from the court to order ARCA to bring the discovery that was ordered in the Commonwealth's discovery motion back on December 5th, 2024. The response by the defense, a large part of it is that it's not within their custody or control. And so these items, I expect, would be in the custody and control of these ARCA witnesses. There are a number of specific items which we sought in our discovery motions. Those items include communications, billing, emails, text messages, etc. And so those documents, if we do not obtain them in advance or the day before the witnesses are set to testify, we will never have an opportunity to send them home to get the materials that are relevant. So if the defense position is not in their custody and control, then I ask the court to order the ARCA witnesses to provide that information prior to the voir dire so that we can review it. Secondly, the defense has provided that they have retained the ARCA witnesses independently. We have received no new discovery other than communications and emails. What is concerning is that in the notice from the defense, there is some suggestion about the ARCA witnesses potentially rebutting or commenting on Mr. Welch's testimony. Discovery deadlines have passed some time ago. It would be inappropriate at this point to have any new opinions, any new information, any new reports. We have been steadfast from the beginning of this case, early on, about discovery deadlines. And so my expectation is if the ARCA witnesses testify, they would be required to testify pursuant to the February 12, 2024 report, and they would not be able to provide any further opinions, any further ideas, or any further reports. So the two things, to simplify it, that I'm looking for is for the court to have that voir dire, again, for a limited purpose, to order ARCA witnesses to comply with the discovery order that the court has already imposed, and to have ARCA limited to the discovery that was properly provided before the discovery deadlines. Those are my three requests.
Okay, who's arguing this?
I will not.
I want to go in reverse order briefly, if I could, concerning the discovery deadlines. We have continued to receive new notices of discovery from the Commonwealth well after the same deadlines that Mr. Brennan is now bringing up concerning ARCA. They filed their notice of completion or certificate of completion long ago, and we have consistently received new information from their experts, new reports, amended reports, redacted reports, additional information. Both sides understand that discovery is an ongoing situation, sometimes out of our control. To that point, on March 26, 2025, we received for the first time official notice from the United States Attorney's Office of the Department of Justice that we, the defense, or either side, the Commonwealth as well, were free to engage ARCA directly as expert witnesses in this case. On that same day, we contacted the Commonwealth. Actually, the very next day, we contacted the Commonwealth and provided them information that we would be and had engaged them. We've provided the engagement agreement. We've provided them with all discovery that we have appropriate thereto. And insofar as, or to the extent that any additional testing and or analysis is completed by those experts, because keep in mind, it's only been, we can count it in days that we've actually been able to engage them. If there is in fact additional testing and or analysis that is noteworthy, then we will, or that we intend to use, we will obviously provide that to the Commonwealth forthwith, which we indicated in our moving papers. We will maintain that posture throughout. And if there is additional information to be disclosed, it will be disclosed. It will be disclosed in a timely manner. We do not have anything as yet as we stand here today, but we.
What do you think a timely manner is? What ballpark are you talking?
When I get a report, I will turn it over the same day. If I get a report, I will turn it over the same day. If I get a new analysis, I will turn it over the same day. If we get new testing results, we will turn those over the same day that we get them. In other words, I can't control the conduct of the experts. They may or may not be engaging in additional testing or analysis, but if they are, once I get it, we'll turn it over. That's all I can say to that. We're not holding anything back. We're not hiding anything. We're, as soon as we get something, if we get it, to the extent that there is additional analysis or testing done, that will be turned over forthwith. With regard to docket number 642, we did, Your Honor, I don't want to waste the court's time. We did respond in detail to every single one of the 12 requests that the Commonwealth has made. I'm happy to go through those if the court wishes me to, but.
Hold on one second. Mr. Brennan, are there specifics that you say are still outstanding of the 13 or however many points there were? Because this is on what you filed. So this is not unusual. A party says, we asked for all 13, another party says we gave them to you, and then the party says, I don't have them. Can we narrow this? Is there anything specifically that Mr. Jackson should address?
Yes. Their response is that it's not in their custody or control.
So for which ones? Which of your numbers?
Number one, a complete statement of all opinions to be expressed by Daniel Wolf.
Okay.
And their response is the information in the possession, custody, and control of the defense has already been produced. That obviously understates the fact that they would hope to have new opinions. That is the very point that this is not responsive. Their discovery deadline has passed. And so I would like to talk about or respond after Attorney Jackson is done about what is going to evolve from this conversation. This is exactly what I was worried about back in November, what I expected might happen and should not have happened. So it's difficult now to parse the different pieces of my discovery request, but we do not have all of the billing, all of the communications, all the text messages, all the emails between the parties. And if the defense's position is not in their custody and control, well, it's certainly in the custody and control of ARCA. We do not have all prior reports, all prior testing, all field testing, photographs, pictures. We don't even know who was what part of this report.
Okay.
And so my tolerance about this ongoing development of discovery is a extraordinary problem for me. This is the number one issue I anticipated and that I've tried to prevent.
Okay. So address number one, Mr.
The
Jackson.
number one issue that Mr. Brennan has anticipated and tried to prevent is ARCA testifying. Let's just call it like it is.
So address number one, please. Okay.
I am. That's what I'm doing, Your Honor. We have provided on April 12th about 1,000 pages, additional pages, responsive to the request specific to ARCA. The response that we provided to request number one is as follows. The information in the possession, custody, and control of the defense has already been produced and can be found in the ARCA report, the voir dire testimony, and the trial testimony of Dr. Wolf and Dr. Rentschler. That is specifically in response to request number one. What we have, they have. Mr. Brennan constantly stands up and says, we don't have all the emails, we don't have all the communications, et cetera. They have everything. We've already turned that over. There is nothing that we have not turned over that's in our possession. With regard to the new information that Mr. Brennan says, this is exactly what I was worried about, et cetera, we could not engage these experts until we got permission from the Department of Justice. The federal government had to give us permission. They gave both sides permission on March 26th, 2025. We immediately, Your Honor, as best we could, leapt into action to contact ARCA and engage them formally so that they could act as experts for the defense in this case in furtherance of potential testimony moving forward. We do not have additional testing results. We do not have additional analysis. We do not have additional reports or findings as yet because it's only been a few days. If we get those, we will turn those over immediately. And that's all we can be expected to do. If the court wishes to go through the others, it's listed as 13, but there's actually 12 requests. I'm happy to do that. If the court's satisfied with.
I have a question. It was my question last time when they testified. It wasn't clear to me who did what each witness did regarding testing, preparation, things that are normal cross-examination. Is that clarified any better? They said we. They talked about we did this, we did that.
Well, I would disagree with that. Dr. Rinchler talked about what he did, which was more on the biological side.
There was a difference between the
and
two.
Dr. Wolf talked about what he did on the mechanical side. They did discuss what their individual or their specific capacity was and their expertise. We have not received any additional report to that effect. Everything that is in the report is exactly what the Commonwealth received at the same time that the defense received it. And it's exactly what they testified to both in the voir dire and in the trial. There's no clarification that we haven't asked for clarification. If there is clarification in any new analyses, that will be turned over immediately as well. But
is there anything that they're going to say they cannot provide because of the federal investigation?
Not to my knowledge. I don't know. I haven't asked them if there's communications that Mr. Brennan is asking for that they can't provide. I haven't asked them that because I've not deigned to.
Can we consult counsel just for a moment?
Sure.
Right. Ms. Lou I was getting to the point, but she emphasized, and I will emphasize it here, the one thing that the U.S. government has said to both the Commonwealth and to us is in furtherance of their testimony, in furtherance of their engagement, they still are not allowed to detail confidential communications that they had with the U.S. government and the Department of Justice.
But can they testify as to what they did?
Yes. Yes, that's
can
on the
they
table.
testify under what direction they did these things?
Well, they can certainly testify to what they did. Absolutely. That is on the table. Every bit of testing, every bit of analysis.
But why they did it?
What their communications were, what their directives were, that is confidential. And
can I see Counsel Tagbar, please? All right, so Mr. Jackson, you're saying that the ACRA witnesses did not do anything, did not read anything, did not consult anything, did not try any additional experiments or come to any findings other than everything that's in that report?
That is correct. That's what we've been told. We have no reason to believe otherwise. Everything that they did, everything they were asked to do, and all the data that they were provided upon which to base their opinions and conclusions is provided in the report, and was all subject to cross-examination, both at the voir dire and at trial.
All right, and then subsequent to that, information was provided by Mr. Yannetti. And you have that all documented, whatever information the ACRA authorities now are working on is information provided by Mr. Yannetti or his file?
So there's two issues. I want to make sure I don't conflate these. Mr. Brennan mentioned a subpoena that Mr. Yannetti had received at his office.
Mr. Yannetti had brought it up in open court.
Correct. That subpoena was honored, as we had to, obviously, as Mr. Yannetti had to honor it. For every single NOD that we got from the Commonwealth, that was then submitted to the federal authorities.
When was that done?
It was done periodically since the subpoena came into his desk.
When did it start?
I don't remember the date. September 1st, 2022.
Thank you.
I didn't remember the specific date, but it was very early on. So the Department of Justice, or the U.S. Attorney's Office, was receiving information pursuant to that subpoena in an ongoing basis. But I want to make clear, that's not information that was then going to ARCA. The U.S. Attorney's Office decided what information, and the FBI decided what information to supply to ARCA to answer their questions.
Do you know what information was provided?
Yes, it's in the report. There were 14 categories of items that were provided to ARCA, and they said that's all that we were provided.
All right, so then it's accurate to say items that are in the notices of discovery that ARCA does not list were not provided to them?
Correct. That's exactly right.
Okay.
Yeah, they were provided a very narrow, it was a narrow scope of work, if you will, that did not include the myriad things that we were getting in NODs.
All right, then you started providing them information to fill in those gaps, right?
Once we received information from Dr. Welcher, for instance, we knew that we wanted at least to explore the idea of rebutting some of that information, from a biomechanic standpoint, and we wanted them to have basically a mirror image of what Dr. Welcher was providing.
All right, so when did you do?
We provided to them.
When did you do that?
I want to say March 26th or 27th. I think it's in the motion. Just take a quick look.
Okay.
Additional discovery for the experts for their review on March 26, 2025. Okay. That same day, the defense was provided all the additional materials to ARCA, including Dr. Welcher's reports and all of his findings, including the 140-page PowerPoint, et cetera. We wanted them to have everything that Dr. Welcher had, as well as Dr. Welcher's reports and findings.
All right, and you say that you will have that, you expect in the next 3 days or so.
Oh, I didn't say 3 days. I said I think we can count it in days, not weeks. So I would expect if there is something that we're going to receive, it's probably in the next week or 10 days, I would guess.
All right.
We are acting as efficiently as we possibly can, but we can only do so much, given the fact that we were only provided access to hire ARCA on March 26th.
All right, Mr. Brennan, I'll hear you.
This is the very issue I've been concerned about since the beginning of this case. And I've made every effort to alert the court that I had a concern, in fact, that I anticipated this very thing would happen. When I began this case, beginning of October, end of September, my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARCA from testifying, never. but it was to preclude the defense from trying this case by ambush. And it was my primary concern. And that is why I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention, notices anticipating, things that are not routine because I knew this very thing would happen. We had ARCA witnesses where I still do not believe we have had full disclosure. Regardless of whose fault it is, I still do not believe we have full disclosure. Not just for the basis of opinion, but regarding communications between the defense and ARCA. That's why I filed this motion for discovery. And when the defense responds, it's not in their possession of control. That's why these ARCA witnesses who've made representations to this court about not knowing the defense and the limited interaction with the defense, they need to be held accountable. That information should come directly from the ARCA witnesses if the defense can't or won't produce it. I believe there will be information that ARCA has if you order them to bring in all of their communications, email, phone call records, billing, and text messages. And if it exists, I would like to see it. I think I'm entitled. The ARCA witnesses provided a report that blurs the roles of the parties. I can live with that. I can accept that. The ARCA witnesses provide a report that does not have a lot of information about their study and notes. I can accept that because I have prepared for it. But what I haven't prepared for is for the defense to wait until the last minute, then move for a tour request, which they know will take time, then provide information to ARCA on the eve of opening statements, and then expect to come in with new opinions and information reports after we've already given an opening statement. It's not only trial by ambush. It not only takes away the Commonwealth's ability and right to prepare, it creates a disadvantage that information and argument is already made to the jury without complete information that they should have had. They could have retained any expert they wanted. They didn't have to wait for ARCA witnesses. They've had 3 years. They could have retained any accident reconstructionist they wanted, but they waited. They moved with a TUI letter on February 7th, 2025. Anybody with experience, including the defense, knows it takes time. If they really wanted the ARCA witnesses, they could have moved in November. We gave Judd Welsh's CV in November. We met our discovery deadlines, and they were hard. There was more we would have done or wanted to do, but we couldn't because we honored our obligations to the court and the discovery orders. We provided the discovery pursuant to the orders so that they would be held to the same standard. And now we hear they waited until February 7th, 2025 for a tour request. And now they're giving new information to ARCA to come back and potentially give new opinions that we have no ability for our experts to evaluate. We have no ability for our experts to then go through and conduct more testing. This is the core of preparing for the case. They had that obligation. And so now to allow them to do this, it's not an aberration. This is a continued pattern from the last trial. They have their ARCA witnesses, they have their report. That is all pursuant to the discovery deadlines. To now let them change the rules and come in tomorrow, the next day, or 10 days from now and have new opinions after we've already told the jury our theory and our science and not have a chance to rebut it or consider it. I'll have no time during trial to sit down with the experts and assign them to review new information, new reports. I'll have no time to go back and reconsider the order of witnesses or the information we need or witnesses that we've decided we don't need in this case and scheduling. If it wasn't so obvious this was going to happen, I wouldn't be so upset about it. At some point, the defense has to be held to the same standard of discovery obligation. This isn't late notice. This isn't parachuting in. This is an effort they decided to make and wait until February 7, 2025. Your Honor, I ask you to allow ARCA to testify, allow them to testify to their report, be confined to the report that has met discovery deadlines, and to produce the request that the court ordered regarding discovery of the information that we want. That's what I asked this court to do.
Your Honor, what appears to be feigned indignation is just not consistent with the facts. We didn't receive Judd Welcher's report until basically February 2025. We received a report, I think it was January 31st, 2025, and we read it for the first time the next day on February 1st. Nobody's been dragging their feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor. The court hadn't ruled that we could even use ARCA until just a few weeks ago. We've been moving expeditiously to try to rebut a witness that the Commonwealth disclosed in February of 2025. By mid-March, we asked for a TUI request. We asked for a TUI permission, or asked permission to engage them through a TUI request. That does take time. We did it expeditiously. We weren't waiting for some advantage. As soon as we got the request approved, we immediately, that day, engaged them, and immediately that same day provided the Commonwealth notice that we had engaged them, and we intend to use them to, at the very least, to address Judd Welcher's testimony or his reports, the last iteration of which we got on March 24th. So if you want to talk about dates and chronology, what's good for the goose should be equally good for the gander. Mr. Brennan has been consistently providing us with new discovery after his certificate of compliance has been well done, the ink is well dry. We have a right, we have an obligation to address and to meet his new discovery. For instance, Judd Welcher's opinions and conclusions, with rebuttal opinions and conclusions, if we can. And I want to make sure that we're not conflating two separate issues. One is the information that ARCA had outside of any of our control. Nobody in this courtroom could have reasonably controlled what information they had.
But you did say that's all listed in the report and there's nothing more.
I was just about to say, the communications that they had with U.S. Attorney's Office, I don't have any access to that. That's confidential. But I do know what they provided to them for their analysis. That is all listed in the report. And both sides have had that from the day we received the reports, the federal disclosures. Both sides have had those. So nobody was in any disadvantage in the first trial, and certainly nobody is at a disadvantage in this trial. We're simply trying to meet our obligations as we could within the confines of the rules that were set up in no small part by the federal government. And now those strictures have largely been lifted, and we're moving forward as expeditiously as we possibly can.
Rather than addressing their obligations, it's always an attempt to assign blame. The government or the Commonwealth gave us late disclosures. The changes in Judd Welcher's PowerPoint were by exclusion. Attorney Alisi had concerns about certain things in the report, so we took things out of the report. There's a difference.
So you first provided it in November, then you're saying?
No, we provided, pardon me. We provided his CV in November, and then we provided on our discovery deadlines, January 31st, 2025. And then on February 5th, we provided all of the detailed background notes, references. And so we met our discovery deadlines. The changes to Mr. Welcher's report have been the complaints, understandably, about what they believed was hearsay or inadmissible. So we removed pieces. There was no new testing. There was no new reports with information changing any of the things.
According to Mr. Alesi, who is much more facile with the facts of what's in Judd Welcher's report, that's not quite true. There were additions made to the latest iteration of his report. And Mr. Brennan just admitted that February 5th was the first time that we received all of the information from Judd Welcher. The next month, within a few weeks of that, That's when we received permission to hire ARCA. That's when we received permission to engage ARCA. That's when we provided the individuals at ARCA with everything that we had been provided just the month earlier. So there is no ambush. There's no attempt at taking an advantage vis-a-vis time. It just doesn't, the arguments just don't play, not with the facts and the chronology of what we've been doing and we're continuing to do.
All right. Thank you. I think is the only thing left the motion to sequester Aiden Kearney to remove him from the sequestration order. Is that the only thing that's now left outstanding?
No, Your Honor. There's also a motion in limine that was outstanding. It's the Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations.
Yes. Where do we stand with that? I thought that you were going to.
We've had a chance to review the file. If there's any statements that are relevant, we think the defense is entitled to use those statements for impeachment or cross-examination. As far as the rulings, the administrative body's rulings, that should not be permissible. It's an opinion of a third party, and then it will open the door to the explanation that those sustained findings are limited to certain conduct, but don't include other types of conduct which we would need to rebut. A third party's opinions are not admissible to impeach a witness.
The defense vehemently disagrees with that assertion. That's not the state of the law. We did provide notice to the Commonwealth of what we intended to admit at trial. The Commonwealth was conversely ordered to provide notice to the defense of what they were specifically asking to keep out. That was supposed to be done 2 weeks ago. I emailed Mr. Brennan the next day after it was due. They did not respond. I was told this morning they're seeking to exclude everything. I would like to be heard on that, Your Honor.
All right. So I don't have a copy of what it is you intend to introduce, right?
No, we provided notice to the Commonwealth, but
So I need that. Do you have it?
I can articulate it to the court. We want to admit the sustained findings that have been made against 4 separate officers in this case.
You know what? I do need that in writing. I need this in writing. I need a Commonwealth's response.
We needed to have a ruling on this in advance of.
Excuse me?
We need to have a ruling on this in advance of Monday.
Right.
I can try to get that to you today.
All right. Get it to me today. I'll decide it tomorrow.
Okay. Are we allowed to make an oral argument as to this issue? It has been briefed already by the Commonwealth.
Okay. You know, what I need is, I wasn't expecting this here today. So what I need is the paper number. I think it's the Commonwealth's motion to exclude, but the last I had it as it wasn't under advisement. You were going to figure out what the objection was and what you wanted to put in. All right, so we need to take a recess anyway so that you can look at the video to see whether there's an objection to the opening. So why don't we take a 15-minute recess? And Ms. Little, if you can provide just the paper number and what the Commonwealth's response was.
It's paper number 588.
All right. So Jim, I need that.
All rise for the court, please.
To have a ruling on this in advance of Monday.
Right.
I can try to get that to you today.
All right. Get it to me today. I'll decide it tomorrow.
Okay. Are we allowed to make an oral argument as to this issue? It has been briefed already by the Commonwealth.
Okay. You know, what I need is, I wasn't expecting this here today. So what I need is the paper number. I think it's the Commonwealth's motion to exclude, but the last I had it as it wasn't under advisement. You were going to figure out what the objection was and what you wanted to put in. All right, so we need to take a recess anyway so that you can look at the video to see whether there's an objection to the opening. So why don't we take a 15-minute recess? And Ms. Little, if you can provide just the paper number and what the Commonwealth's response was.
It's paper number 588.
All right. So Jim, I need that.
All rise for the court, please.
Going into recess. Yeah, once again, where did they leave it? They left it at the Commonwealth was to do something. The Commonwealth didn't do what they were supposed to do while they are coming into court trying to invoke their diligent compliance with the deadlines. They didn't do that. Why am I not surprised? Why am I not surprised? So they were supposed to specify what do they want out. We did have argument about this. It goes to bias. Goes to bias and it goes to the Bowdoin defense. So, Brennan is trying to present this parade of horribles that, oh my gosh, if you let this in, then we're going to have to go down the road of explaining what it was based on and what it wasn't and so forth. Yeah, that's called rehabilitation. That's right. When your witnesses get impeached with the fact that they were sanctioned for how they did their jobs on this investigation, you can try to rehabilitate that. You can try to say, well, it was just about this and not about this other. You can try to do that and see if the jury cares. You can try. Boy, he does not want Arca coming in, does he? Really doesn't. And he's tried to play it off like he's so unbothered. I don't really care if Arca testifies. I remember him saying that at one of the earlier hearings. No, you filed a motion to exclude them, so I'm pretty sure you do. Pretty sure you do. You wouldn't file a motion to exclude if you don't really care if they're going to testify. But you figured out they're going to be able to testify anyway because you had everything that they were going to testify to before the last trial. And then certainly after they testified, you knew what they were going to say. So you definitely didn't want it in. You definitely didn't want it in. And then, scurried and struggled to try to make an issue out of the defense paying them for their time appearing. You got that? You wanted to try to convert that into something. All right. You get to use that. It's new information. It didn't exist at the last trial. It was disclosed to you. You get to use it. Go ahead. Try to argue it proves that Arca's biased. Going to run into a real difficulty here with not opening the door. Really going to run into a difficulty here. Yeah, they really need to know before opening about the IA stuff. That's pretty important. Who all was it? It was Tully. It was Proctor. It was Buchanan. Who was the last one? Who was the fourth? Who was the fourth? It's not Kevin Albert. Kevin Albert wasn't part of the investigation, and I don't recall that he really got sanctioned anyway. Did he lose some vacation time? Was that it? Yeah, I can't even remember. We have Proctor, Tully, Buchanan. Maybe she means Kevin Albert. I don't know. I don't remember another MSP officer. Lank. I see folks in the chat saying Lank. I don't remember Lank getting a sanction. What would he be sanctioned for? Fanning? Was it Lieutenant Fanning? Was it failure? Did he get a failure to supervise or something like that? It could have been. It could have been. Well, Bev says we'll get a ruling tomorrow. Ruling tomorrow. So I guess that means we won't get rulings on these other things that they also really need. They really need a decision on. Putting herself pretty close to the wire there. This is not the easiest issue from a legal standpoint, because it does get into things like bias and so forth. Okay, so this might be the good segue to talk about what part of the problem is here with, I mean, it came up with the Welcher report. It's going to be an issue with the Canton police audit if anybody wants to use that. The Commonwealth is now trying to use it with respect to these IA processes. And that is the ability to bring in the hearsay through the review or through the expertise or whatever. And so I mentioned before, very common in many jurisdictions that experts, they can bring in evidence. Give me a sec. They can bring in evidence that isn't otherwise admissible if it is part of the basis of their opinion and it's the type of thing that they ordinarily rely on as part of their expertise. So for example, if you're a lab analyst and it's normal for you to rely on the reports of other lab analysts who aren't testifying, as part of your process, then you can testify about that in many jurisdictions. But Massachusetts is not one of those. Massachusetts, in fact, very specifically says the expert can only disclose the basis of their opinion if the basis for their opinion is otherwise admissible. So they can only rely on admissible evidence when it comes to forming their opinion. So that's why we have potential issues here with what exactly can be said and how it can be fleshed out and stuff like that. It's the problem the defense had with Mr. Welcher, because he just basically said, I accept these stories and these things that other people said and these reports that I read. He presented them as though he's kind of the adjudicator of what's true and what isn't, and then relied on that for purposes of reaching his own conclusions. And, that under the Massachusetts rules, that seems like a pretty legitimate objection. And even Mr. Brennan apparently conceded that's a legitimate objection. They can't do that. So that is very much going to be an issue with this Canton police audit as well, because their conclusions rest in large part on what they were told by people at Canton PD. They could testify to their own personal observations when they watched things happen, when they saw things happen, but they can't go in and, for example, review the police reports and then parrot what those police reports said as proof that it's true. They could talk about the fact that police reports were made, to get to like the requirements, the protocols, whether they met standards and so forth for taking reports. But you don't get to go in and be like, oh, the Canton Police Department handled the Karen Reed and the Karen Reed investigation just fine, because according to the report, they went and collected evidence in solo cups and used the leaf blower to clear the lawn. You don't get to do stuff like that. So that's really going to limit, as far as I can tell, what's there in that police audit that is even potentially admissible in court. And then, so we saw it with Welcher, we saw it with the Canton police audit, and this is the other place where that is likely to show up, is in this IA process. There will have been evidence. You know, this was a trial. This was like a small little mini trial. There would have been evidence, presumably, whether that's live testimony or you know, affidavits, witness statements, exhibits submitted, things like that. It's often for the case that administrative types of hearings, they are very similar to regular trials that you have in court. You don't always necessarily have the formalities of a courtroom where you come in and you know, witnesses come in person and swear and testify. Like you often do a lot of stuff over the phone or by Zoom or whatever. But it's very similar. People come in, they're sworn in, they give testimony, and the administrative officer makes findings based on that. And that's kind of necessary because administrative processes, they also, you have to have due process for those. Exactly what process has to be given can vary, but when you're talking about somebody's right to their employment, especially if this is a right that is supported by, you know, collective bargaining agreements, civil service laws, etc., for you to deprive them of that, they're going to be entitled to quite a bit of due process. So it really has to mimic, in many ways, that trial proceeding, because the administrator can't act in an arbitrary way. They can't just decide, I don't like this guy, so we should get rid of him. No, they have to find that there's been a violation of policy that warrants a sanction, and they have to have evidence to make that finding. They can't just make it out of thin air. These people say it went like this, these people say it went like that, we'll flip the coin and see. No, that would be arbitrary. But the problem is that all of that information, it's taking place outside of court. It is hearsay. So unless it is independently admissible, it can't come in as part of the basis of their decision. Not clear to me that the defense is proffering that. I appreciated Ms. Little was ready to just articulate for us everything that the defense wanted to come in. Judge isn't going to have that. I need it in writing. Okay. I mean, we've already had motions on this, but okay. They obviously want the finding in. And Mr. Brennan's effort to kind of get out of that by saying, well, the finding is just the opinion of a third party. No, the finding is an act. The finding is an act that they took to sanction these individuals, to impose discipline on them based on their conduct in this case. That's why the sustained findings matter, because they were the basis for discipline. What more than that does the defense want in? I don't know. I don't know. Guess we'll keep our eyes open for something in writing. We'll see. Well, let's see what you guys have had to say. Freddie York, for what will the Commonwealth claim that the crash dads were paid for if they aren't allowed to mention the first trial? Well, that's the million-dollar question, isn't it? How do they square that circle without opening that door? How do you try to get into bias, suggesting that the defense controlled this, without getting into the specifics of exactly what did the defense pay for versus what didn't the defense paid for? Because they're entitled to rebut a misleading suggestion that they paid for all of it. Commonwealth can't go in there and suggest they paid for all of it. They get to correct the record on that. No, we didn't pay for all of it. We actually didn't hire these guys to do their investigation. We only hired them to testify. I suspect the answer to this is it will be that same sanitized type of language that we heard in the first trial when they were talking about the grand jury testimony in a prior proceeding. testimony in a prior proceeding. That'd be my suspicion of exactly how they'll be allowed to do it. But I think the Commonwealth would be well advised to be very careful here, because you can open the door a little bit wider than potentially you intended to if you are not extremely careful with the implications that you give the jury. Jeffrey B, what if anything, haha, brings me back? Yeah. That one goes way back, doesn't it? That one takes us all the way back to Depp versus Heard. It takes us all the way back to Depp versus Heard. That was how they worked around what was erroneously, in my opinion, designated as leading questions. If you ask a yes or no question in that court, it was apparently leading. It's not. It is not leading to ask a yes or no question. What is leading is to ask a question that already communicates what answer you want. So if you don't give them the option of yes or no, you only give them the option of yes. Isn't that correct? That's leading. But anyway, that's just my personal beef. I always take issue with that. People over applying this limitation on leading questions. But that was the workaround. What if any? What if any? And then certainly, yes, the last trial. That was like every other question out of Mr. Lally mouth. What if anything? Pamela with a super chat. Thank you so much for that, Pamela. Really appreciate your support. Sandra M, so excited to be here with you again. Question, if Bev is outright illegal on her rulings and defense calls a sidebar, can she still uphold her bogus rulings? Well, in terms of her power to do so, yeah, she can. She's the judge. She gets to decide, and their remedy for her making illegal and bogus decisions is to appeal them if Karen gets convicted. That's the way the system's set up. That's their recourse. There is a presumption, I guess, or a sort of premise that the judges are going to try to make the right decisions over the course of a trial, and that's why we sort of assume that it's good faith and they're doing their best. And if they make mistakes, I mean, everybody makes mistakes, but maybe it's it's inadvertent, it's not something they're trying to do. So that's why just the ordinary process of review in the Court of Appeals is your recourse for that. But I think, it might be fair to question whether that is really a fair assumption a lot of the time. Is that really a fair assumption? The judges are doing their best to be impartial and act in good faith and make the correct decisions. At a certain point, you see enough of a judge's record that it really calls that into question. When you see the judge relying on law that doesn't support the proposition that she's asserting it for, when you see her using it in a way that is very plainly outcome driven. She wants to reach an outcome, so she is, or having her clerks, search the case law to try to find little pieces that she can use to support where she wants to get. Tends to show the judge is not really interested in an objective and impartial evaluation of the law and relying on that to decide the issues in the case. So it may not be a good assumption a lot of the times, but they're not going to change that. Maybe the legislature, if they wanted to, they could create a different type of review process. They could do that. Are they going to do that? It's the same political pool that's appointing this judge that's proposing the legislation in the state of Massachusetts. So I'd be kind of surprised if that happened. So yeah, to answer your question, she can, as a matter of her power and her authority, do whatever she wants, and their recourse is to appeal it. Michael Muddragon, whoo, you're the only YouTuber I can listen to at double speed and not miss anything. I do kind of speak a little slowly, guys. I know, I don't know. I don't take it personally. If you want to speed me up, speed me up. It's totally fine. I got in the habit of speaking very slowly when I was working with elderly folks, and also, but kind of the similar token with juveniles. With elderly folks, because you often have hearing issues, and so just the more slowly and clearly you articulate, the less you tend to have those issues. With juveniles, just because you have an understanding gap. And you want to be clear that, you know, we're trying to keep up with each other and talk to each other on the same level and avoid any type of misunderstanding. But I realize that means some people speed me up. Go ahead and do it. Caught up now. I hope the name Honk Brandon catches on. Was that in the closed captioning? The closed captioning is often just a gift. There are many fun things that it gives us. Also, sorry for the loss of your dog. Here's a virtual hug for you and Jeff. Thank you very much. And thank you to everybody, all of your kind words. I did put up a post on my community tab. We did lose Rupert this last weekend. So no snores from the old dog during the retrial. He was 13 years old. It was a good long life for a Vizsla, but it is always hard to lose them. So thank you for that. Track worker, HB lying when he says other files are in KR file. Well, what exactly is this guy downloading and why? This is talking about the DGM Petro download, right? Or is it now something else, the detective files? I mean, how many places are these freaking Sallyport videos? How many places are there? Is it his responsibility to download every bit of Sallyport video all the time? And then if it is, why would you have all that in one place and only in one place? It's just very, it's so murky, this explanation that keeps evolving that we've gotten for the Sallyport video, where it came from, why they had it in the first place, what exactly they had, where it was kept, who got it, why didn't it get turned over? The story just keeps changing, and the judge is remarkably incurious about any of that. Not at all gravely concerned about the lack of disclosure and the shifting stories. So he says it's in the detective file. In the detective file? What even is that? What does that even mean? It's all very confusing. But it implicates privacy. He says it implicates privacy.
Court is back in session. You may be seated.
All right, so the first thing I viewed the clip. Is this only 15 seconds? Did I see everything you intend to use?
I expect that's only 15 seconds.
Okay. Was there any objection to what you saw?
No objection.
Okay, thank you.
I would say that's only the audio. There's a visual that goes with it, but because it comes from a broadcast, we have to copy it differently.
Okay.
That's the audio, but there will be the visual with it that was aired.
Okay. I was able to see the video.
Super.
Okay. All right. Were you as well, Ms. Little?
Yes, we were able to see the video and we have no objection. And I did also provide, there's only a single photograph we intend to display. It will be an admitted exhibit. I provided a copy to counsel. I will also send that to the court as well.
Okay, thank you. All right, I'll hear you on this motion. Ms. Little, I'll hear your response to the Commonwealth's motion.
So during the break, we had an opportunity to discuss this issue with the Commonwealth.
Okay.
I believe we are in agreement on most of the issues.
Okay.
They have agreed that we are allowed to bring in the sustained findings as they relate to Trooper Proctor, Trooper Buchnick, Detective Lieutenant, and Detective Lieutenant Tully.
Okay.
The only issue that we need to work out, Your Honor, is with regard to Kevin Albert. And so we will continue to discuss that. I'm not as concerned in terms of timing with that particular issue.
Okay.
If the court will give us, another day or two to discuss with the
Sure.
Commonwealth, if there's a remaining issue, we can address that promptly with the court.
Okay. Can we address, is it something you need for your opening?
It's not.
Okay. All right. So yes, we'll address it sometime next Tuesday or Wednesday. Take your time in working it out. All right.
Thank you.
Okay. So now is the only thing left the motion that Mr. Bradle's here for?
As far as I know.
Okay. All right. Morning, Mr. Bradle.
Good morning, Your Honor.
Okay. So, Jim, you have that. All right. I probably have it here too. I have one, Jim. Thanks. All right. I will hear you. Let me just ask, Commonwealth, you're moving to, sorry, you stay right there, Mr. Bradle. Mr. Brennan, you're asking for sequestration on all the witnesses other than the ones that have already been decided, right?
I'm not sure I understand.
So there was already an order on who is exempt from the sequestration order, family members. We discussed, and there was an order on all of this.
Yes.
Are you asking that Aiden Kearney be sequestered?
I am. He's a named witness.
Okay. Does the Commonwealth intend to call him in your case in chief?
It depends on the development of the case. There are two issues that are important. The one in case in chief is whether or not there's any development of third-party culprit. If there is, Mr. Kearney becomes a more important witness, and we'll have to assess that as the case progresses. The other is rebuttal. If the defense calls the defendant to the stand, then it is a strong likelihood that we would call Mr. Kearney.
Okay.
Those are two things that I can't anticipate at this time.
Okay. All right. Now I'll hear you, Mr. Bradle.
All right, thank you very much, Your Honor. Judge, we don't have an offer of proof. I'll try to argue in the interest of time, and I think I know where the court's going with this, based on the prosecutor's statements and the context. So with that understanding, Judge, I would just start by saying that, there's really no reason to beat around the bush here, Your Honor. The Commonwealth is not going to call my client, Mr. Kearney, who for the record is in the second row here today.
Can I just ask, if he were to call your client, would he take the fifth?
Yes, Judge, and I just should clarify for that.
Okay.
That is under the government's, the obviously well-established position of Norfolk County law enforcement. What we contend is a twisted interpretation of the witness intimidation statute, that seeking to contact witnesses, seeking to question people is witness intimidation.
Okay, so just focus back on.
So the answer is yes. I'm sorry. The answer is yes, Judge.
Okay. So let me hear from you on that, Mr. Brennan.
Sure. Your Honor, under the government's interpretation of this statute, Your Honor, the government is seeking to first.
No, I'm sorry. What I said was, I'll hear you, Mr. Brennan. And you.
Oh, I'm sorry.
But that's okay. I don't want to hear about the witness intimidation statute, other than if I don't sequester your client, I would be inclined to do just like I did before. The witnesses who are the subject of the indictments, Mr. Kearney will have to be outside the courtroom when they testify.
We anticipated that, Your Honor, and I won't say that we would agree to that, but I understand the court's position there, and I can see that would be a resolution the court might land on.
Okay. Now I'm going to let Mr. Brennan speak, and then I'll hear you again, Mr. Bradle.
Thank you.
Your Honor, you have questions?
Yes. What if he takes the fifth?
If he asserts his Fifth Amendment privilege, I think there is no realistic likelihood that we would call him. There's obviously procedures the Commonwealth could follow, but I have no belief that will happen. So I expect if he actually asserts his Fifth Amendment privilege would no longer have a good faith basis to say that there would be a need for sequestration. I would ask the court to impose the prior limitations with named victims and also minor witnesses.
Okay.
But I would, as a predicate, he would need to assert his Fifth.
Do you need that to be done formally, or do
Yes.
you want it to be done formally?
I do.
Mr. Bradel, do you want to do that now?
Judge, I'm happy to assert that on his behalf.
Would reject that invitation. If he wants to assert the Fifth Amendment privilege, he can assert it.
Okay. Do you want to call him now and do that now, Mr. Bradel, or not? Do you want to talk with your client? And
7 minutes.
sure. Why don't you know what? I'll give you more than a minute, Mr. Bradel. Can the staff work through lunch for a little bit?
Yes.
Everybody stay. All right. Mr. Bradel, why don't I give you 10 minutes to talk to him? We'll see you back here in 10 minutes.
All rise for the court, please.
Of other people?
I think there is no realistic likelihood that we would call him. There's obviously procedures the Commonwealth could follow, but I have no belief that will happen. So I expect if he actually asserts his Fifth Amendment privilege, would no longer have a good faith basis to say that there would be a need for sequestration.
So,
I would
like
ask
he
the court
told
to
you
impose the
he's
prior
going to?
limitations with named victims and also minor witnesses.
Okay.
But I would, as a predicate, he would need to assert his Fifth.
Do you need that to be done formally, or do
Yes.
you want it to be done formally?
I do.
Mr. Bradel, do you want to do that now?
Judge, I'm happy to assert that on his behalf.
Would reject that invitation. If he wants to assert the Fifth Amendment privilege, he can assert it.
Okay. Do you want to call him now and do that now, Mr. Bradel, or not? Do you want to talk with your client? And
7 minutes.
sure. Why don't you know what? I'll give you more than a minute, Mr. Bradel. Can the staff work through lunch for a little bit?
Yes.
Everybody stay. All right. Mr. Bradel, why don't I give you 10 minutes to talk to him? We'll see you back here in 10 minutes.
All rise for the court, please.
So they want it on the record in the form of a kind of offer of proof, I guess. And my suspicion for why Mr. Brennan wants to do it this way, he wants his questions on the record. He wants his questions on the record. That's why he knows the cameras are here. He's not a fool. He's not a fool. That's what this is about. Of course, you wouldn't have a good faith basis to call him as a witness if you knew he was going to invoke. And you were told he will invoke. So why are we here? Because you want to do it in front of the cameras. That's why. That's why. So, okay to bring in the Satane's findings for Proctor, Buchanan, and Tully. Why was this even an issue? They had to chat over the break to resolve that. They shouldn't have had to have that chat. See, what shouldn't happen is the Commonwealth taking these flat positions that we oppose everything and then having to backpedal from it. That's what should not be happening. But it happens over and over and over and over. We're going to do this, and then they backpedal. We're going to oppose this, and then they backpedal. But still have to work out Kevin Albert. Still have to work out Kevin Albert. So the issue with Kevin Albert had to do with during the investigation, he and Proctor went on that little joyride over to the Cape. Oh, wait, no, I'm sorry. They were investigating another matter. A cold case. We're following up on a cold case. So they went over to the Cape and they partied and they got real shit-faced. And then Proctor, I guess, drove him home. Also while drunk. That was part of the IA case. That was one of the findings that led to the discipline, although it was the least serious of all of them. But with Kevin Albert, there was the text messages about, did you ever find my gun? You find my gun in your car? He lost his freaking gun. Lost his freaking gun during this little blowout party at the Cape with Trooper Proctor while this investigation was going on. So my suspicion is that the reason why the Commonwealth has a problem with it is because, of course, Kevin Albert was recused. He was recused from the investigation of Karen Reed. And so, didn't have anything to do with that. That was the main reason why the Canton Police Department as a whole was recused, because Kevin Albert, the brother of Brian Albert, the homeowner, works at the Canton Police Department. So he wasn't part of the investigation. This whole joyride incident didn't have anything to do with that investigation. Meaning, it was related to a different. So the fact that he was sanctioned for it, I guess, doesn't necessarily matter. What the defense is going to care about in this whole context is Proctor's conduct. That's what they're going to care about. I don't think they care so much about Kevin Albert's, other than the fact that it was because of his partying with Proctor while this investigation was going on that he left his gun in Proctor's car. And because of that, Proctor got sanctioned. Let's while we're waiting, keep going with the comments here. My Mini 67 RA, I'm up here yapping, but in my head, there's no arguing with stupid. Bev is clearly outgunned by the defense team. This is Robert Alessi. He's a smart guy. He's a hard one to keep up with. They're all exhausted at this point, and it's just going to get worse and worse and worse as trial goes on. So we are going to see how that affects them. Does that affect their ability to be sharp, be on the ball, be responsive, catch things? So far, doesn't really look that way. I mean, he's still making his point, and honestly, maybe even a little bit better than he was when he was a little bit more well rested. But yeah, I think I don't know if intimidated by Mr. Alessi is exactly the right word, but I feel like she has to have learned that she needs to proceed with caution with him. When he smacked her down on that, no, Your Honor, it was not a Google search. I consulted with the head of the former head of the National Academy of the Sciences for Geology to get these studies. That was a smackdown. You're dealing with a caliber of lawyer that you're not used to. You're dealing with a caliber of lawyer that is head and shoulders above where you were when you practiced. Did you consult with the National Academy of the Sciences, former head for geology, when you had a question, Judge, or did you just do a Google search? Use an AI bot if you really need, then it's super neutral. This is about the reading the text. I mean, maybe, but I don't know. I mean, the point is what the Commonwealth is proposing is just kind of nonsense, because there is no lack of inflection in reading. Reading is reading. If I'm going to read something from my notes, HB, yes, want HK excluded. I just, it's a note. I'm not trying to emphasize anything, but that's just how you read it. Yes. Yes, you're going to emphasize it because that's the point of the note. And so it's very difficult. I like Mr. Jackson's argument here. I think his point is an excellent one. This was not an actual spoken conversation that Karen and John had with each other anyway. And it is often the case that tone doesn't carry over in the written word. And people misinterpret text, misinterpret comments on social media, misinterpret emails and stuff like that all the time because they hear something there that isn't there. And so to try to convert this text communication and all of the possible variations in how it could have been understood or misunderstood by both sides, that is kind of imposing an interpretation of this communication on the jury in a very suggestive type of manner. So it would be appropriate, I think, for the defense to invoke the best evidence rule here. Now, I'm not 100% sure they follow it in Massachusetts, but I would assume they do. The best evidence rule is generally that testimony about a written document is inferior. The best evidence is the writing. It's the document. So when it's the text messages themselves, the best evidence, it's the text messages. Just put those into evidence. The jury can read them. The jury can argue about tone and inflection and what was emphasized and what wasn't and all of that. I think logically that makes the most sense to me, not having it read out at all. This wasn't, if this was like recreating a conversation that was had, that was documented, okay, maybe then I could see having a reading, but this wasn't a spoken conversation. So it doesn't make sense to try to translate it into one. Andrew Hansen, have text to speech read it. I think text to speech would probably be the most neutral form of writing because it would be that, you know, Karen, why did you hire the plumber? I told you I would come and do it. You know, it would be like robotic. Is that helpful? Is that helpful to the jury? How is that more helpful than just giving them the written text? I don't think it is. But yeah, as far as if we're going to read it, that seems to me like probably one of the best options. Greg, let's call it what he is. He's still trying to hold on to the blow up he caused Bev to have with the ARCA witnesses. Yeah, he is. Yeah, he is. He's trying to stretch the candor to the tribunal, and invoke that. Why you think that? I think there's probably a lot of stuff you have that you haven't turned over. I think of the video, you did it anyway. So those are my reasons for thinking you probably did do that. But you've given no reasons, no reasons for why you think there are other communications and arrangements and so forth with ARCA that you haven't received. No reasons at all. Where's the good faith basis for that assertion? Would have been nice maybe if the defense had put that out there. You know, they're making these very, very strong insinuations that the defense is lying about what there is. What's their good faith basis for that? Because remember, we weren't going to do that anymore. Remember, it was very outrageous when the defense does it. Remember that? But the defense continues to not try to really fight back about this stuff. They try to just calm the waters and placate the situation and be the adult in the room. It hasn't worked for over a year. At some point, guys, you need to take the gloves off. You need to take the gloves off and you need to punch back. That's all I'm going to say about that. Sarah Boone's left kidney. Why does defense have to give convos with ARCA? Isn't it work product? They're discovering